All right, perfect. Well, good afternoon. Yes, it is afternoon, just barely. Thank you, Dr. McClanahan. Appreciate that. And I'm Jim Beyer. I'm the Director of Human Resources. Am I able to move around, or is the microphone not going to pick? I probably better stay here. Okay, I'll stay here. Like I said, Jim Beyer, the Director of Human Resources for the Medical Center at Beyer since the end of September. So I'm real new on the job, but I'm not new at all for human resources work in healthcare. I've been practicing as a human resources professional for well over 25 years and been in medical either through practice administration or through human resources for 30 years. So not a clinician, but I've certainly been working closely with individuals like you for a long, long time. It was a really pretty orange slide. I don't know what happened to it, but oh well. All right, so today we're going to talk about 4 different things very quickly about when do you involve human resources. Today, obviously, we're talking about from the standpoint of OSU Medical Center. I know there's some other employers, residents that probably you represent here also, and so there may be slight differentiation there. And so, just double check with the Human Resources Department where you're dealing with. Also, we're going to talk about examples of reasonable accommodation requests, what happens during the EEOC interactive dialogue, kind of who attends it, what does it look like, those sorts of things. Then we're going to talk about just in general some aspects and ideas concerning fairness, equality, and equitability. So like I said, today when we're talking about fitness for duty, as Dr. McClanahan said, it can be a physical impairment or it can be a behavioral health impairment. Today our focus is kind of on the behavioral health side, but oftentimes we're talking about things from migraines to ski accidents and how you come back to work and just all kinds of things that can be physical also. Okay. So when do you involve human resources? Well, first of all, we really want to make sure that it's based on objective evidence. When we talk about impairment can be really tricky for those of us in human resources. Maybe not so much for you as a clinician, but for those of us in human resources, it can be really tricky. Impairment, and I've seen it, probably every one of these examples, it can be impairment due to illegal drug use. It can be impairment used because of the use of legally prescribed medications taken in excess. It can be sleep deprivation. It can be a panic attack. It can be any other mental health condition or situation. There's just a lot of different reasons that it presents itself. From a human resources perspective, if somebody comes to us and says, I've got an individual that I believe might be impaired on the job, our first approach is typically to go to a for-cause testing, drugs, alcohol, etc. And that's, if nothing else, that rules out some things that it might not be. Because if it's illegal drugs, then we have a much quicker path of where we know that we're going, those sorts of things. So again, that impairment can be really, really tricky. The individual on this objective evidence, we want to make sure that we are evaluating that they are unable to safely or effectively perform their duties of their essential job functions, or they possess some sort of a direct threat to others. So if they're behaving in such a manner that it creates a threat to themselves or others. And like I said, so for purposes of today, when we talk about the impairment and we talk about a reasonable belief attributable to a physical condition of behavioral psychological impairment, we're presuming that we've already ruled out maybe substance abuse or illegal drugs and that sort of thing. So not that different from what Dr. McClanahan said. Our central purpose from an HR perspective is to make sure that we are determining whether the employee is able to safely perform the essential functions of their job, either with or without a reasonable accommodation. That's the piece that we are geared with under the American Disabilities Act, and making sure that they don't pose a direct threat. The psychological fitness for duty examination or evaluation, as you can call it either way, it might be the next appropriate step. That's kind of what we've been talking about here. There are other remedies for impairment, and they might include things like education, training, a physical function, fitness for duty examination, employee discipline, i.e. illegal drug use, those sorts of things might come into play also. But partner with your HR department. Get us involved in that. There's like 2 parallel paths that are going on here. We've got the program itself and we've got the employer. And I could imagine there could be a situation where as a program, you might need to take some actions with a participant that is maybe outside of their employment. But it's hard for me to imagine a situation where, as the employer, that we would be concerned with something that didn't also involve the program. I don't know what it might be that would be only the program itself, but there could be something that could be an accommodation strictly having to do with the learning environment rather than necessarily the job performance environment, that sort of thing. But it's two parallel paths that are happening as a program and as an employer. So the fitness for duty process, and really, Dr. McLennan covered that very well, so I won't go too much over this, but a qualified mental health provider that she talked about, we're really looking at those job essential functions, those job duties. As the employer, we want to provide that information to you. In the case of residents and fellows, obviously you know that, and Dr. McLennan is going to know those essential job functions and duties. But we also want to provide that evaluator the evidence, the information, the objective indications as to why are we asking for this in the first place anyway as the employer. We'll give a copy of the medical release. She's exactly right that records held in the employment process are not PHI, protected healthcare information, and so it does fall outside of HIPAA. But we're going to provide that medical release. We're going to have that employee sign, giving us permission as the employee. She already mentioned that the program is going to get the copy of that information also to evaluate not only the employment relationship, but also the participation in the program. And then we'll make for those payment arrangements. And so typically, we don't usually run through medical insurance when it's initiated by the employer, but we'll make some kind of payment arrangements. And obviously, if it ends up being Dr. McClellan, then we know that there's some opportunities for some payment, special handling there. So we very appreciate that from ourselves. So the fitness for duty should come back to us, again, not that dissimilar from what you've already heard. The person's fit for duty. Okay, they return to work. Or they're unfit for duty, and we might have to look at Family Medical Leave Act because maybe they have to be off work for a certain period of time. We might have to look at some sort of other medical leave if they're not qualified for Family Medical Leave Act. They haven't met the eligibility requirements. They've used up their FMLA, et cetera. So there could be some situations there where we have to evaluate that also. It could even ultimately end up in a separation from employment, not that dissimilar from what Dr. Song talked about. There are instances where it's not going to be able to continue with the employment relationship. Or most of the time what happens is we're looking at some sort of a fitness for duty with modifications, with restrictions, with some sort of accommodation need. And that's where, as an employer, we've got to respond to that request for an accommodation. We've got to either accommodate it and say, yeah, we can do that. That's not a problem. Or we've got to enter into this Americans with Disabilities Act, Equal Employment Opportunity Commission, interactive dialogue. It's somewhat of a term of art that they use to make sure that we're participating in that process. The accommodations can look like just about anything, but some of the ones that I've seen that have occurred are you start later, you end earlier, you have extended breaks, you change something about noises or lights, you have to provide some sort of equipment, you need to be able to take certain medications while you're at work, provided they do not impair you further. Sometimes it's job restructuring, sometimes it's reassignment into a vacant position. Obviously, that's not going to be applicable to a resident necessarily, but again, as the employer, we're dealing with more than just residents. We can also take suggestions from the employee, and we can offer suitable alternatives that the employee says, well, I think I need this. We're allowed by law to be able to say, well, that's a great idea, but here's why that's not going to work. But we have a suitable alternative instead. And so those are the kinds of things that will come out of that interactive dialogue. So during the interactive dialogue, back up a second, with a roller here, I may have on past one. In that interactive dialogue, we will have various participants. There we go. I'm going to talk about that in just a second. So back up. In addition to this fitness for duty evaluation, sometimes the employer would want to seek a second or even a third opinion. Third opinion would typically come up when the employee has gone to their general practitioner, their family practice physician, come to their employer with some sort of a finding or a request for an accommodation, et cetera, and we say, well, I think we're going to have to request a fitness for duty evaluation. And we invoke that second opinion, and the two are conflicting. And so, for example, on FMLA, you're only allowed to get a request for a second or third opinion if you're validating the authenticity of the information. But you could, the FMLA rules, the laws, the regulations, talk about how you would get that second opinion, and if it conflicted with the first opinion, then you could pay for a third opinion. The Americans with Disabilities Act, which is where we spend most of our time in these kinds of conversations, is silent on the second and third opinions. And so the general consensus is that second and third opinions are indeed permitted under the Americans with Disabilities Act, but only with respect to insufficient information. Now, that can mean, well, we didn't get everything that we needed from that provider. We need some clarification on something. Not just, well, I don't really like what that person said, so I requested the first one. I'm going to get that second opinion, and I'm going to request a second opinion. We don't get to really just keep shopping until we get the answer we want. That's not something an employer can do. And in the case of second and third opinions, the employer also pays for that. So what happens, Dr. Salm talked about this request form to be developed for the program. We would have a similar type of approach with your employers. We're going to have a similar approach. In this particular case, when that form gets developed, we might take the information after the fitness for duty examination, and if it comes out of that with accommodation, then we can say, okay, somehow we've been made known of that accommodation request. We have a formal meeting, but it's with informal discussion. It's a dialogue. It's going back and forth, and we as the employer are trying to learn about the accommodation request, what exactly is really needed, how we're going to be able to engage in that process, etc. So we always include the department decision maker. So in that case, that's going to be those of you in the room who are program directors. It includes our employee health nurse, and then it includes somebody from human resources, myself, or one of our other members, who is going to be there on kind of a dual role. In human resources, we talk about we're always a little bit of a split personality. We're there to advocate for the employee and at the same time be a fiduciary back to the organization and to the program. And so we're kind of working out that dual role, but that's why we're there to help facilitate the discussion. The outcome itself is never prescribed. You never have to come out and say, we know this is what's going to happen. But the event, the dialogue, the meeting is required. So we always want to follow through with that. Unless it's as simple as, here was the results, here's the requested accommodation, and the employer says, yeah, we can do that. The partner says, yeah, we can do that. And great. There's no reason to have an interactive dialogue if everybody agrees that we can make the accommodation. So during that process, we may request medical information regarding disability, the second or third opinions. I say see below, that should say see above. I must have changed my slide order there. But generally speaking, when we come to a request for accommodation, the onus of making the accommodation falls upon the employer to make an accommodation. Unless and except, it would create an undue hardship on the organization. It would create a direct threat to the individual or others, or the employee still would not be able to perform those essential functions. Great example that Dr. Tom used. She was talking about that. So generally speaking, that at a very high level covers the interactive dialogue process, the request for accommodation, the when you call HR, call your HR department, whoever it may be, whoever the employer may be. But I also want to hit just briefly on this general concept of fairness, equality, and equitability in the workplace. As human resources professionals, these different concepts become applicable in different situations. So, for example, when we're talking about fair, I like to think of that as it's objective. There's no favoritism involved. There's no discrimination based on a person's race or gender or religion or sexual orientation or age or veteran status, etc. All of those protected areas, when we talk about being fair, we make decisions irrespective of those influences. So a good example there is in the hiring decision. When we're hiring an individual, when you're picking out residents for your program, you need to make those decisions fairly. Sometimes we have to work on things that are equal. So, for example, that's got to be something that's going to be the exact same for everybody. The number of days to elect your insurance coverage is 30 days, not 28 days for some of you, 31 for some of you, and you only get a week. So sometimes we have to be equal. We almost always have to be equitable. So that's where we're talking about being reasonable and just. So for example, when we're doing new hire salary calculations, when we're doing employee discipline aspects, and when we're deciding whether or not an individual should be requested for a physical fitness for duty evaluation, we need to make sure that we're being, A, fair, but also equitable. We need to be reasonable and just and appropriate for the situation. So we're always seeking that fair and equitable. You hear us say that a lot. It's a little bit of a wrap-up, so we're talking about these medical examinations under the Americans with Disabilities Act. There are a lot of terms and regulations and requirements, but primarily the biggest one is it must be job-related and it must be consistent with the business necessity. So that's a fairly easy hurdle for an employer like a medical center, like a residency program. Pretty easy hurdle to jump over business necessity. So pretty easy to jump over the hurdle of job-related also. So we're almost always going to be able to get there as long as we have made the selection fairly and equitably. And then these ADA medical examinations, consistency, consistency, consistency. Let's always make sure that we apply them uniformly to similarly situated employees. And that's another term of art that the law would use, that we apply them in the same manner, i.e. either same occupation or same medical condition or similar circumstances, even if it's not the same occupation or same medical condition. It needs to be fair and equitable so that we don't find ourselves all of a sudden disparately treating some who might be in a protected classification that we're not disparately treating others. So with that, I will turn that over next. Again, if you have any questions, my contact information will be on your handouts.